The Introduction to the New Commonwealth Model of Constitutionalism by Stephen Gardbaum. The Commonwealth model represents a third approach to constitutional arrangements that falls between two formerly mutually exclusive options of legislative and judicial supremacy. The new approach is said to be optimal for protecting the rights of citizens in democratic states by balancing the existing legislative and judicial models. It may prove to be an appealing compromise between the two extremes. However, some have suggested that the new Commonwealth model may find itself in an excluded middle ground and fade away. The new model purposely distances itself from the traditional or old model, which was a model built upon legislative supremacy. The traditional Commonwealth model had no codified Bill of Rights. Instead, rights were changed and created by the legislator through ordinary statutes only when a situation called for it. Under the traditional or old model, courts had no power to review or overturn any legislation which potentially infringed on rights. Rights under the old model are a direct product of legislation and therefore can be manipulated under it. The legislators held significantly more power over the judiciary. It was their job to determine the legal rights of citizens and how specific rights issues were to be resolved. The traditional legislative supremacy model of constitutionalism proved to be a great failure. It completely lacked in preventing totalitarian takeovers and failed to protect human rights, common law rights, and freedoms. The new model adopted the principles so that legislative power is legally limited and courts are empowered to enforce these limits via judicial review. The end of the Second World War marked the beginning of a human rights revolution, which called for something other than legislative supremacy. The new Commonwealth model is tied to the development and implementation of international human rights. The revolution was evident in the paradigm shift from extreme legislative power to a more favorable judicial supremacy. After World War II, a number of countries abandoned legislative supremacy for some sort of judicial enforcement of a codified Bill of Rights. Currently, in Western Europe, the Netherlands and Switzerland are the only two countries that do not allow any form of judicial review of national legislation. The shift towards limiting the power of national legislature was not unique to Western Europe. And in the early 1990s, a number of Eastern European, Asian, African, and South American countries adopted new constitutions and embedded rights which are dubbed supreme law. The new Commonwealth model is said to be the grandchild that spawned from the post-World War II rights revolution. The new model was the result of embedded rights which could not be modified by the legislator while maintaining reliance on institutional means. The shift from legislative supremacy to judicial supremacy was simply trading one extreme for another. Countries such as Canada, the United Kingdom, and New Zealand tried to establish a middle ground in which rights were to have greater legal protection without the exclusive reliance on judicial power. The new model is mindful of and contains recent trends of human rights international law. To apply it at a domestic level, it must fall between a fully constitutionalized Bill of Rights and full legislative supremacy, relying on a balance of two institutions and a shared responsibility for rights. The new model employs a weak judicial review, which is essentially judicial review without judicial finality, which in turn allows the legislator, which in theory represents the will of the people, to be granted the opportunity to have the final say. The shift towards the new model was not necessarily met with open arms with both the Liberals and Conservatives. And in fact, of the new Commonwealth countries, only in New Zealand is the Bill of Rights generally supported by both major political parties. The Canadian Charter of Rights and Freedoms comes with a notwithstanding clause, Section 33, which, in short, eliminates the possibility of judicial review and overrides guaranteed rights. However, the new model is the combination of two ways to protect citizens' rights, with a mandatory pre-enactment of political rights and a weak form of judicial review. What makes the new Commonwealth model different than constitutional supremacy is that it is supposed to transcend legal forms of rights and provide an answer to the general question, how should power be institutionalized in a democracy? This shift leads to an embedded and judicially guaranteed constitutional Bill of Rights, which supersedes any conflicting legislation and essentially negates Parliament's majority vote.